we're commonly dealing with clients charged with offences in relation to illicit drugs. Most people have some understanding of the general law around illicit drugs in Queensland. They know the basics of possession and what that means. However, when it comes to the offences further up in our drug offence hierarchy, offences of supply and trafficking in dangerous drugs, these tend to be widely misunderstood concepts within the community. And often people can find themselves in really serious trouble based largely on a misunderstanding of the way that the law in relation to illicit drugs in Queensland operates. Possession charges are essentially the starting point, the lowest step along the chain in terms of drug charges in Queensland. Possession is a wide-ranging legal concept which includes physical possession, as well as other instances where, while not in physical possession of an item, the law might deem someone to still be technically in possession of it and allow them to be charged and even convicted with being in possession of that item. When it comes to supply and trafficking charges, however, the law is even broader and less clear in terms of the degree of conduct involved. Commonly these days we see people charged with supplying dangerous drugs arising from text messages found on someone's mobile phone. The broad, wide-ranging definition of supply allows people to be charged and convicted with supplying dangerous drugs simply for offering to supply dangerous drugs or doing an act in furtherance of a supply. This can include responding to someone who's asked to purchase drugs and doesn't need to involve an exchange of funds or a commercial element in order to satisfy the charge. Supply charges in relation to what are called Schedule 1 dangerous drugs, synthetic drugs like cocaine or amphetamines, for example, are charges that in our system must proceed upon indictment and be resolved before the district court. For many people, this means a period of 12 to 18 months from their first date in court before their matter can be resolved, and often an enormous amount of stress over a lengthy period trying to resolve things with a favourable outcome. Trafficking in dangerous drugs is simply defined under our laws as being in the business of supplying dangerous drugs. Commonly, young people in particular find themselves being charged with a trafficking offence in circumstances where the business they were operating may not have been turning much of a profit, and they may have viewed themselves as simply being the person who was able to help out friends by sourcing drugs or supplying drugs to them. Trafficking in Queensland is a charge that has to proceed to the Supreme Court in order to be finalised, and commonly results in sentences of imprisonment being imposed for people who are convicted of that offence. It is essential, if you're charged with an offence of supplying dangerous drugs or trafficking in dangerous drugs, that you seek legal representation by a lawyer who's familiar with these areas and experienced in representing clients in relation to these matters to ensure that you avoid an unfavourable outcome.